Hello everyone, my name is Satyam Shivaach and I'm working as a legal intern with LEXIS and Company. And in this video, we will discuss about sale of immovable property. The sale simply means buying and selling of goods and services. Under the Transfer of Property Act, the sale of immovable property. Before jumping into further details regarding the sale of immovable property, let us first find the meaning of the different keywords which are necessary in order to understand it. Section 3 of the Act is the interpretation clauses and provides as immovable property which does not include standing timber, growing crops or grass. An instrument as means of non-testamentary instrument. The instrument is a written document, a formal or written document in writing, as a contract, deed, bond and lease of anything reduced in writing. Then there is a registered. Register is a book containing all the records of fact as they occur and kept in public authority, a document which cannot be said to have been duly registered if the registration has been made in the contravention of the provision of the Registration Act. Then there is attached. It is a term which describes the physical union of two otherwise independent structure or object, the relation between two parts of a single structure, each having its function. Now let's see what is section 5. It basically talks about transfer of property defined. The transfer of property means an act by which a living person conveys property in present or future to one or more other living person, or to himself or to one or more other living person, and to the transfer of property is to such perform such act. Some of the means of transfer of property has one person to another one by sale, exchange or by gift or by adverse possession, and even by decree by the court in some cases. And section 54 of the Act defines sales and specify how a sale of immovable property may be made. Herein, sale refers to as a sale of immovable property, whether tangible or intangible. Sale is a transfer of ownership for a money consideration. It implies an absolute transfer of all the right in the property which has been sold, and no right is in a property sold after left with the transferor. Now let's see what is section 54. Section 54 says sale is a transfer of ownership in exchange for a price paid or promised or part price and part promised. Let's see how a sale is being made. Such transfer in the case of tangible immovable property of a value of 100 rupees and upward, or in the case of reversion of or other intangible things, can be made only by a registered instrument. In a case of tangible immovable property of a value of less than 100 rupees, then such transfer may be either by a registered instrument or by delivering of that property. Now let's see the delivery of tangible and immovable property which takes place when the seller places the buyer or such person as the direct in possession of the property. Contract of sale. A contract of sale of immovable property is a contract that a sale of such property shall place on terms settled between the parties. It does not of itself create any interest in or charge of such property. Now let's see the elements of sale. First is the transfer of ownership. The ownership of the aggregation of all the rights and liabilities in a property. Where there is a transfer of ownership, the aggregation of total of the all rights and liabilities of the property are transferred from one transferor to the other transferee. Then there is money consideration. The price that is being referred to in section connotes to money transfer consideration. Where the ownership of the property is transferred into consideration for money, it amounts to sale, but it is transferred for anything else in amount of exchange. Then section 54 provides that the contract of sale of itself does not create any interest or in charge of such property. Now let's see what are the essential of a sale. First is parties. In a sale, there must be at least two parties. The person who transfers his property is known as the transferor, and the person to whom the property has been transferred is known as transferee. Then there is competency. For a valid sale between both the buyer and the seller, there has to be competent on the date of the sale. First is seller. The seller must have the ownership of the property which he is going to sell. Then the seller must have a legal title to it, only then he can sell the property, and the seller must be competent to a contract. Moreover, he should not be a minor and must not be a person of unsound mind. He must not be a statutory incompetent person, and the seller may be by nature personal jurisdiction person, for example corporation or another legal person. Then there is of buyers. The buyer must be competent to receive the ownership of the property, and the buyer should not be disqualified from buying the immovable property by the law enforced at the time of the sale. Moreover, the seller may be a natural person, juristic person, for example a corporation or other legal person. Then the next thing is subject matter. Sale and the transfer of property especially deals with the sale of immovable property. The immovable property includes the benefit arising out of the land and the things attached to the earth, except for standing timber, growing crops and grass. The right to catch and carry away fish is a profit pattern and the constituted as immovable property. Then the next thing which is essential in the transfer is money consideration. Price is an essential element for a sale, whereby the transfer the vendor is getting rid of all the liabilities to pay certain sum. It cannot be said that there is no consideration for the sale. An agreement between the parties cannot be rendered nugatory to the grounds of the consideration which was not adequate. The price paid and the price promised to stand on equal footing as regards the transaction of a sale. There is nothing illegal or contrary to public policy if the parties agree for the payment of the consideration, and it shall be postponed in certain events, or that it shall not be paid to all the property when it is lost. Then the next thing is convenience. Section 54 provides two models of transfer of property. First is the delivery of possession, and second is registration of sale deed. The delivery of possession is where the property is the tangible immovable property of a value of more than 100 rupees or upwards, and the transfer can be made only to a registered instrument. Where the property is intangible, immovable property of a value of less than 100 rupees, its transfer may be made either by registered instrument or by delivery of property. The delivery of tangible immovable property takes place when the seller puts the buyer on such person as the buyer directs in the possession of property. Then let's see the registration of sale deed. Where the value of the tangible property is more than 100 rupees, the sale of such property requires registration of the deed. Where the property is intangible immovable property of a valuation, it will require registration for completion of the sale. Then the last thing is the registration. A combined reading of Section 8 and 54 of the Transfer of Property Act suggests that through execution and registration of a sale deed, the ownership and all the interest in the property passes to the transferee. Yet, that would be on the terms and conditions embodied in the deed, indicating the intention of the parties. The intention of the parties can be gathered from the averment in the sale deed itself and by other attending circumstances. Registration in prima facie proof is the intention of the seller that he wants to transfer the ownership on the date of the execution. That is all for today's video, guys. Thank you for watching. Please like, share and subscribe the video.